Hi everybody, welcome to our channel where we answer immigration questions. Today I'm going to talk about the difference between common law relationship and marriage in terms of immigration applications, more specifically spousal sponsorship, whether it's an inland application or an overseas application. We represent clients that are either in a common law relationship or they've been married and they have a marriage certificate. And I'm often asked the question by clients when I do a consultation, is it okay if I'm in a common law relationship, or should I get married to my partner in order to make the application better or stronger? So the answer is that you could be married, and you qualify for spousal sponsorship, or you can be in a common law relationship and you also qualify for spousal sponsorship. In immigration law, you're allowed to sponsor your common law spouse or your married spouse. There's no difference between both in terms of the strength. So one is not better than the other. Therefore, the answer is that you decide with your partner what's the decision for you. We have clients that are religious, they want to get married. We have clients that are not religious but believe in the institution of marriage and they get married. We have clients that do not believe in marriage and they want to be common law partners. They've been living together for many years. We have clients that have been married for a year or two and they qualify for common law relationship. We also have clients that have previous marriage, but they're not divorced yet, or they're not able to get a divorce, or divorce might take a long time, and now they're in a new relationship. And for example, they've been in a common law relationship for many years, but they're not divorced. They can still qualify for spousal sponsorship. For example, we have a lot of clients from the Philippines where it's very difficult, almost impossible to get a divorce unless you get an annulment, which could be very expensive. So most of our Filipino clients that are submitting spousal sponsorship that had a previous marriage, they're not divorced, but they have now a common law partner, and they can proceed with that. So in terms of documentation, if you're married, obviously you need to have a marriage certificate. The marriage needs to be valid in the location that where the marriage took place. It also has to be a marriage that's recognized by Canada, but you don't have to necessarily get married in Canada. You can get married anywhere in the world. And currently, in the last few months, immigration has made some changes for the spousal sponsorship documentation. So even if you are married, the marriage certificate is now, it's not sufficient. There's also other documentation in terms of if you're living together, or if you're married but you're in a long distance relationship, there's also a set of specific documents. Now for common law partnership, there are also very specific documentation in terms of cohabitation. The document checklist is very specific and it's now regularly changing, so it's very important to make sure that when you submit your application, you really look at the document checklist. For example, for common law relationship, you have to prove that you've been living together, and just a lease agreement, for example, is not sufficient. You, for example, might have to have your driver's license. You and your spouse have to have the same address. You might have to submit joint utilities where you're both on the documentation. So those are now very strict requirements, and if you don't have those documents, whether you're married or in a common law, and you submit your applications, there are good chances that either your application is going to be refused or it's going to be returned to you a couple of months later, and then you can lose some time. So to summarize, if you're in a relationship, you're dating somebody, it's been a few months, if it's been a few years, and you're ready to you want to sponsor your partner, and you're not sure if you want to get married, or should you get engaged, get married, you want to live together, or maybe you've been living together and now you want to think about immigration. The way to go about it is not to say, well, what's stronger, marriage or common law? This is a very personal decision for your relationship. So you and your spouse have to discuss, because if you get married, there's a lot of things that come into play as a result of getting married. There's a lot of rules that get triggered. If you ever get separated and you want to engage in divorce proceedings, it could get quite complicated. I always recommend my clients to consult with a family lawyer if they want to get married. And if you don't want to get married, but you're going to live together, and if you do that, you qualify to sponsor your spouse, there are also some rules that get triggered once you live with somebody, and there's other obligations and responsibilities that don't, because you're not getting married. So it's really a personal decision, and whichever path you choose, then if you submit the application yourself or you choose to hire a lawyer, you have to prepare your application in a specific way. So that was the answer for whether if it's marriage or common law. Like I said, it's a personal decision when it comes to that. Thank you for listening, and see you next time.